think about what are the bad emails or what are the bad text messages. Especially, I really want to look at who sent them, who received them, and how bad are they. The higher up the senders or the recipients, the more it may look like an enterprise level problem.
Hello, and welcome to a very special episode of FDA Watch. We're the leading independent, nonpartisan podcast on FDA. I'm your host, Wayne Pines. I'm very excited about this episode. It's the third and last installment in another of our signature multi-episode series that we produce in collaboration with law firms and other organizations. We call this series Drug Pricing Pressure, Navigating Regulatory Complexity. And what we're looking at, what we've been talking about, is the intersection of FDA regulatory strategy and competition and antitrust scrutiny and enforcement risk and transaction design in the life sciences industry. We have two sponsors, two support for this episode and for this signature series. Two great organizations. One is the law firm of White Case and its life sciences group. And secondly is BRG, which helps clients navigate the financial compliance and transaction consequences of drug pricing pressure. The motivating factor of this series is to address the drug pricing issue in an FDA regulatory context. We are FDA Watch, so we talk about FDA. Historically, of course, FDA has avoided anything having to do with drug prices. It still doesn't get involved with setting any particular price for a drug. But in this environment, FDA regulatory issues obviously affect pricing and also affect how a company does business. And that's what we're going to be talking about today. Some of the laws and government policies and interactions with healthcare professionals and insurers that affect how drug companies conduct business. If you missed either of the first two episodes, give them a listen. You go to fdawatch.net. I'm going to repeat that. I say it many times on every one of our episodes, fdawatch.net. In our first episode, we had two guests from White Case, Bethany Hills and Raul Rao, and John Barquette from BRG, and they discussed government policy and how it's deployed to navigate drug pricing across agencies and Congress. In the second episode, we discussed what happens when pricing pressure reaches the FDA and the realities of that situation. Bethany again joined us, and we also had Dan Troy from BRG. And in this final episode, we're going to be discussing enforcement and what risks can result from drug pricing decisions. We have two great guests. Lauren Papenhausen is a partner at White Case. She focuses on litigation and investigations. She has more than 20 years experience representing pharma companies, biotech companies, labs, diagnostic companies, and her practice includes anti-kickback and false claims defense and internal investigation. Welcome to FDA Watch, Lauren.
Thank you, Wayne. Great to be here.
Also with us is Edward Buthusiem. He is the managing director of BRG's health analytics practice. He is also a leader in the firm's corporate compliance and risk management practice and a co-leader of its pharmaceutical valuation practice. And just getting to know Ed over the last few weeks, I know that he is ultra busy and he is an expert witness in a number of cases going on simultaneously. So I'm glad that you have the time this afternoon to take time to talk with us, Ed. Thanks for being here.
My pleasure, Wayne. Looking forward to it.
So let's talk about potential risks. I want to start out by asking Lauren, how do pricing decisions and access pressure distort behavior inside companies in ways that can create other government-related exposure? I'm thinking specifically about the False Claims Act and the Anti-Kickback Statute. I've been involved with those laws for some time. But Lauren, let me ask you to start out, for those of our listeners who are not familiar with those laws, and especially as they affect the drug industry, define the area and briefly explain what these laws require in the context of the drug industry. I'll ask you to start out, Lauren, and then Ed, ask you to add on.
Sure. So everything that we're going to talk about today really lives in the shadow of these two statutes that you mentioned, the False Claims Act and the Anti-Kickback Statute. So start with the False Claims Act. At a very basic level, it says that you cannot knowingly submit a false claim for payment to the federal government. In the drug world, what this means is that every time a prescription is filled for a Medicare or Medicaid patient, a claim goes to the government. And the amount that the government pays is driven by pricing data the manufacturer reported. Things like average sales price for Part B drugs and average manufacturer price and best price for Medicaid. So you have a simple chain. Manufacturers report pricing data, the government uses that data to set reimbursement, providers submit claims at those rates, and then the government pays. So if the pricing data at the front end is wrong, all of those downstream claims can suddenly become false claims. And that's the structural risk that exists there. Now, the anti-kickback statute. The AKS makes it illegal to offer or give anything of value to induce or reward the use of products paid for by federal healthcare programs. In practice, what that means is that you cannot give prescribers, patients, pharmacies, or channel partners something of value with an eye toward driving prescriptions or purchases of a federally reimbursed drug. And anything of value, it's important to know, can be very, very broad. It can include not only cash, but speaker fees, travel, copay assistance, free goods, hub services that might lighten the administrative load in a busy office. It can even be data or software that would have business value for a pharmacy or a hospital. The other piece then that comes into play is the government pricing framework itself. So AMP, best price, ASP, these are all legal reporting obligations that are tied to whether a manufacturer participates in Medicaid and Medicare. Every contract, every rebate, every fee, every free goods program feeds into those calculations. So if you misdesign a commercial arrangement so that it's left out of the calculation, you have an FCA problem, even without any kickback problem at all. And if you design that same arrangement in a way that also provides value to prescribers or to channel partners, then you can trigger AKS and FCA together.
And let me ask you to elaborate a little bit on that. Over the last few decades, False Claims Act and the Kickback Statute have been very prominent for the drug industry. Can you put that into, that kind of a context, and especially with regard to key TAM cases and what's going on in that area? It used to be there were a lot of key TAM cases. Now they're not publicized as much, so it's hard to tell how many there are. So a little context.
Sure. And just by way of background, I spent 22 years in the pharmaceutical industry at GlaxoSmithKline, and I've lived through this, and I've lived through sort of the evolution and the proliferation of the use of these statutes in this area. And I think one of the issues is when you look at the economics of drug pricing, and, for example, when you calculate the government price as best price, it really requires almost a metaphysical analysis of what goes into that calculation from the gross selling price to the net selling price, the reportable price to the government. Because I think, as Lauren's mentioned, there are so many pricing components and parties involved, but between the setting of the price from the manufacturer all the way through to the product, being dispensed. So you've got so many different types of programs and so many different types of discounts being offered to the retail pharmacy, to the distributors, to the specialty pharmacies, and then government programs like 340B, which is basically community hospital-based programs for drugs dispensed in those hospitals. And then you add to that the complexity of the PBMs, who serve sort of as the middleman to negotiate price between manufacturers, distributors, and pharmacies, and health plans. So when you put all that together, again, living through that, it really has taken a long time for the pharmaceutical industry to get their heads around the manner in which they track and account for these payments. And when you look at some of the first False Claims Act cases, any Kickback Act cases that were brought, typically they're brought for conduct relating to prior periods, off-label promotion, out and out bribery. The issue in a pharma company is the here and now, predicting the future. Because, again, when you're being prosecuted or you're being sued civilly for prior conduct, many times by the time the action has been commenced, the conduct's been remediated, and then you're focused on, okay, what's next? What's next? And I think when we talk about what's next, and we'll get into it on this podcast, there are a number of new theories being pursued by the government and by civil qui tam plaintiffs. And I would say that, as we all know, qui tam cases, I believe in 2025, were an all-time high.
So that means that presumably employees or former employees are bringing more cases against the pharmaceutical industry now than they were several years ago. I mean, it's increasing, or
75% of the qui tam cases brought last year were in the life sciences industry, and the vast majority of those were against pharma companies. So I think that is a correct statement. And again, we're seeing novel theories being pursued. And I think what's really surprising here is that we're seeing unprecedented success in qui tam cases against pharma companies following DOJ declinations. So notwithstanding a DO declination, these cases are being brought, and they're being brought through to successful verdicts or settlements. And I think that is a new phenomenon that's continuing on, or likely to continue on this year as well.
And Wayne, if I could just jump in, I think Ed is exactly right that we're seeing record numbers of qui tam cases each year, higher than the last for the past few years. But I think the one interesting twist that's new there, you had mentioned, Wayne, is these relators, these whistleblowers, are they all former employees? What we're seeing in increasing numbers nowadays is that it's not just the usual suspects of former employees or maybe competitors bringing these cases, but we're seeing lots of cases generated by data miners. And so these are people who are using the publicly available claims data, publicly available Sunshine Act data to hunt for and find, and in some instances do really sophisticated data analysis to identify these cases and bring these cases as relators in a qui tam case.
I think that's a really good point, Lauren. I know the government is also using AI. They're using very sophisticated algorithms and methodologies to look for anomalies. And as Lauren said, it's not limited to the government, because if you have access to claims data, relators have access to this data, they can perform the same or more sophisticated analyses to look for these outliers, same as the government's doing.
Are all these cases instances where the companies are defrauding the government, or is it inadvertent, or is it mistakes? What's going on? Lauren, let me start with you based on your experience and then turn to Ed.
My experience as someone defending these sorts of cases is that a lot of times the data can be misunderstood, and what's going on can absolutely be misunderstood. And especially as we get into these claims that are really based on data, based on looking at outlier patterns, a lot of times what we find is that the government, the relators, don't understand what they're looking at, and they don't understand the data. And so it really means digging into these things and trying to understand exactly what's going on here and trying to explain as best we can to the government what's actually going on here. That just because you see some pattern or just because you see some outlier doesn't mean that anybody is is out there committing fraud on these.
Yeah, that's your perspective on that. Is it fraud or what's going on?
Well, I would just expand on what Lauren said. Now, many times, like you have an opportunity to meet with the DOJ. If you've gotten a subpoena, you've gotten a letter, it's under seal during the investigation to seek a declination, and you'll have an opportunity to present your data facts to Lauren's point, where there are anomalies, but they can be explained, where you go through the claims data, you go down all the way to the chart reviews, medical necessity, whatever it is. And we know that the government, under the Polanski Supreme Court decision in 2023, they have very broad discretion in issuing declinations and seeking dismissals. So what we're seeing, though, is even in cases where you've convinced the government to essentially issue a declination, we're still seeing these cases being pursued, and in many cases successfully, because the fact that you may be able to convince the government doesn't necessarily mean you're going to be able to convince a jury to understand the data and draw a distinction. And what we've seen, particularly with litigation funders out there willing to bankroll some of these cases, they're willing to take their chances. And there have been some very, very big verdicts and settlements over the last couple of years against pharma companies, even in the face of these declinations, based on the same data that the government looked at, the company presented, juries, in many cases, reaching a different conclusion.
I do think it's worth noting one of the morals of the story here is, with all of this access to data and relators and the government out there digging into the data, the more that a company can understand its own data and understand what its own data shows, the better prepared it will be when an issue comes up.
Well, that's exactly what I was going to ask you, and that is, what would you advise? So I'm a client, I'm a drug company, and I come and I say, I see what's going on in this environment. What do I do for my company to prevent this? Let me ask you that. What do I do to prevent this? And I'm asking the same question of Lauren, because I'm sure you get that question all the time.
Yeah, and the government will. So the first and foremost, it's imperative you have a very robust compliance, auditing, and monitoring function. And that means conducting periodic audits of the data, conducting your own internal pricing audits, either yourself or through a third party. Because the more you do, the more monitoring, the more internal controls you have around that, you do get an opportunity to seek a declination or a diminution under the federal sentencing guidelines if you can show that whatever fraud is alleged is not systemic. So I think it's an imperative to have a very active, very proactive compliance program that involves, particularly when you're talking about government pricing and rebates, an active audit and an active monitor. And whether you're a provider or you're a pharma company or you're an insurance plan, it's imperative that you engage in those routine audits to see if they're outliers, so you can get in front of the data.
Lauren?
I agree with everything that Ed has said. To elaborate a little bit, I think that it's more than just doing audits of your data, doing monitoring activities. Of course, you do have to have a very strong compliance program. But one key point about data that I've been seeing in a lot of recent cases is what people are calling the compliance void theory. So the government is now explicitly penalizing companies that may have very sophisticated data and monitoring and AI capabilities, and that are using those capabilities to drive sales, but that are not using those same capabilities to detect abuses. And so I think a critical piece here is marrying those up, making sure that the same sort of sophisticated data analytics that your sales organization is using are also being used by your compliance program to try and identify any issues.
So compliance programs need to use more AI. Is that what you're saying?
Not necessarily, but I think that if there are technologies that other parts of the commercial organization are using that are data related, I think companies would be well served to be using those same technologies for their compliance program, because that increasingly is something that the government is going to expect to see.
I couldn't agree more. And I had a recent case, won't name names, but I got an opportunity to do a fill factor presentation to DOJ involving a fraud case. And what we did was, to Lauren's point, very, very sophisticated company in the pharma space. And companies use AI in many different ways. They use it in finance, they use it in financial forecast and planning, they use it in drug discovery to predict which molecules in drug discovery or in clinical development are more likely to succeed. But what you have found is that with respect to internal investigations, doing keyword searches are still based on relatively old technology, either relativity searches, but not the same AI technology that the companies are using. So we ran in and we went in and we ran a beta test. We did it, we took the company's internal investigation through its outside firm, and we ran our own AI investigation using the same tools that the company was using in its other parts of the business. And we found 20% more elements of recurring fraudulent patterns that were determined in the first instance. So to Lauren's point, I think that because the government's now using this, there is a growing expectation that you will use cutting edge technologies in these investigations and not rely on the old tools and have that stand up for something like scrutiny for a fill factor assessment where you're seeking a diminution and in a fine or a penalty.
Yeah. The early TTM cases were brought generally by, let's say, sales reps and others, disgruntled employees who claimed that the company was trying to promote off-label. That environment has changed now, and now we're talking about a much, much more sophisticated and more difficult for people like me to understand as to what companies need to be wary of as they're developing pricing structures. So is that what's going on?
I would say yes and no. So I think we are still seeing some of what I think of as the old-fashioned perennial favorites of DOJ enforcement, things like physician speaker programs. Those have been a key focus of DOJ enforcement for many, many years, and we're still seeing large settlements there. But I do think on top of that, we are seeing some newer, as Ed said, more cutting edge theories. So in the price setting realm, for example, one thing that I would think about and be really cognizant of as a company in terms of emerging risk areas is these sort of price reporting cases. So for Medicare Part B drugs, for example, there's been increasing pressure on average sales price, or ASP. So 340B pricing, for example, has really pushed down those average sales prices. And what this does is this gives potential incentives to companies to find ways to counteract that downward pressure. And then I think you have further exacerbating that situation is there are new CMS rules that took effect in April of this year relating specifically to ASP price reporting and specifically designed to encourage greater transparency and rigor in the data and the methodologies that companies are using around this price reporting. Essentially, CMS is now requiring manufacturers to show their work in terms of how they do these calculations to a far greater extent than they ever have before. And so it wouldn't surprise me if coming out of that, we see greater government enforcement around ASP reporting as the government now has this expanded opportunity to see exactly the methodologies and the assumptions that companies are using.
Yeah, and I want to ask you to build on what Lauren just said. She mentioned speaker programs, but we also have copay programs, patient support programs, all sorts of programs that companies are engaged in. Talk a little bit about those programs and how they play into this environment.
Sure. Pharmaceutical companies participate in a highly competitive market, and you will have the uninsured or the underinsured population that does need access to medicines. Now, when you have a copay assistance program or a payer assistance program, typically they are driven by a financial needs assessment. So, it's something that a manufacturer will sponsor to assist folks who are either uninsured or underinsured. And again, by going through a financial needs assessment, you directly with the company, and typically what the companies do is they will outsource the administration of these programs to a third-party administrator, a reimbursement hub or somebody like that who will adjudicate these types of determinations. But once they are adjudicated, that assistance is provided, and in effect, it becomes a subsidy to the actual payment of the drug. Now, what the government has alleged in several cases is that this type of program can lead to increased utilization because, as Lauren said, described anti-kickback, it's essentially the payment of goods or services that could result in increased utilization. So, the theory is that when you use a copay program, use a payer assistance program, it can relate in greater utilization because you're giving broader access. And then the issue is, how was it done? Was it done lawfully? Was it done to ensure that there are proper bells and whistles around the bona fides of the program to ensure that it is really bona fide in terms of making an assessment based on facts and data, based on financial need as opposed to something else. But they will continue to be under scrutiny. Any payment or support payment to a key opinion leader or speaking arrangement or anything will continue to be under scrutiny. Although the rules, following the Open Payments Act enactment around transfers of value to key opinion leaders have really changed, vastly changed. So I think that probably, those types of arrangements with physicians, at least in the pharma industry, probably less in scope, but payer assistance program and copay assistance program, charitable programs will continue to be in scope because they'll follow the money.
Right.
I very much agree with that. I think that the copay assistance programs, the copay assistance charitable foundations continue to be a very hot area of enforcement. And I think the reason for that makes sense. It's not just, as Ed said, increased utilization, which of course is a factor, but the Department of Justice, DOJ, has been very open in saying that they view these copay assistance cases as, at bottom, pricing issues. So they view their cases in this area as really an attack on artificially inflated drug prices. Their view is that companies are evading the safeguards on high drug prices that Medicare's copay structure would otherwise impose when they offer this assistance to patients who can't afford their copays.
On that note, we're going to take a short break. Don't go anywhere. We'll be right back. And we're back. We're talking with Lauren Papenhausen from White Case, Ed Buthusiem from BRG, and I wanted to ask you a few, very practical questions. Lauren, you represent a lot of these drug companies. Ed, you're an expert witness, and you work with these drug companies. When you're approached by a company that's got a problem, how does it play out? What documents, what decision trails, what control questions? What are you looking at, Lauren, first? What are your first questions?
My first questions and what I think about is what really matters most is I think about what are the bad emails or what are the bad text messages. Especially, I really want to look at who sent them, who received them, and how bad are they? And the reason for this is that the government will very much look to these informal communications for evidence of what's the intent, what's the internal pressures that the company is under that might provide a foundation for them in building up their intent case. And the higher up the senders or the recipients, the more it may look like an enterprise level problem. Also, the government is always looking for anything that looks like a cover up, anything that looks like an intent to bypass compliance controls. All of that is going to shape the whole narrative. And so those emails, those candid communications can be really, really critical. The other thing I always want to look at is what does the data show? Because the question is, does the data tell a story that will let you either say there's actually no issue here, or does the data tell a story that might let you draw a clean line around the issue? Oh, it only relates to one product, one region, one small team, one narrow time period. And so I always want to know, what does the data show?
Ed, when you're brought in whatever capacity, let's say as an expert witness, what are the first questions that you ask?
So I think particularly recently, there have been new theories advanced by the qui tam bar. I'm involved in 2 cases now that are fairly novel theories. So the first thing I do as an expert, we do our due diligence to be able to take the case. So I'll typically do a case assessment up front, and it involves, if it's a farmer pricing case, we'll run our own analytics with counsel, and we'll look at exposure analysis. We'll look at trending analysis. We'll look at along the decision tree. When it's something sort of less obvious than a pricing decision, but still related to price, because in pharma, most things ultimately are related to price, I'll have to examine the theory. So, for example, one of the new theories that's being advanced, and there's actually a split in the circuits, is there is a case, and it's public knowledge, Silvershire versus Janssen versus a number of other defendants. But that case is interesting because Silvershire is a patent lawyer, and he's brought strike suit, qui tam suits. He's not a whistleblower, but basically acting on behalf of the government. His theories in the case he's brought, he looks for cases in which patents have been asserted in the Orange Book, against generic manufacturers, and have subsequently been either invalidated or withdrawn. And his theory is that, well, you've committed fraud in the patent office, for example. You obtained a patent fraudulently because, for example, the one case I had, you really misled the government. You provided data on commercial success that was fraudulent. So therefore, any sales that came out during the period when the generic would have been on the market constitute a false claim to the extent they were reimbursed by government. So that's a case where we had to really do due diligence. We had to look at the patents. We had to look at, commercial success factors, and we had to look at the data. But typically for me, I'll want to do our due diligence. The new trend we're seeing now is, as you know, the DOJ and the Department of Homeland Security just established a trade fraud task force. And we're now seeing the first qui tam cases coming through that are alleging that trade fraud, either manipulating the tariff, during the Trump tariff wars to achieve a different price and not passing the savings on to the government programs, constitutes a false claim. We're also seeing country of origin marking cases that are claiming, fraudulent country of origin markings, again, to save money on the tariff. And the theory there is the tariff, you should have paid the higher tariff, but the lower tariff, you save money, should have been passed on to the government as a savings. So it really, from my perspective, by the time I'm involved, the suit's been filed, or if it's a DOJ case, I may be involved to seek a declination. But typically in qui tam, case has already been filed, and we're trying to understand the theory and then mount a defense.
Yeah. So Lauren, I'm a member of a board of a company, of a drug company. And I come to you and I say, I'm aware of this new environment. What should the board be doing to address some of these issues and to adopt preventive measures to protect the company?
I would say there are three key categories of questions that a board should be asking about right now. One is compliance around pricing calculations. What sorts of controls and processes does the company have around pricing calculations? For example, the ASP calculations. And again, I expect ASP price reporting to be more under a microscope than it ever has been before because of these new CMS reporting requirements. And so I think it's going to be increasingly important that these assumptions, all of the assumptions that go into the pricing calculations, are validated and audited, and that the company is taking a consistent approach across its products. The second key area, I would say, is to really focus on asking questions around what is the compliance program doing in connection with the company's highest priced drugs, or its drugs that are the highest percentage of the Medicare spend. Because what we've seen is that those are the drugs that are going to draw the most government scrutiny. And so they're the drugs that similarly should be getting significant scrutiny from a company to really understand, what are the auditing and monitoring activities we're doing around promotional activities? What sorts of audits are we doing around price concessions for those very high-priced drugs? The third key area I would say the board should be asking questions about is data. How is the compliance program making use of the company's data? Again, we've seen this increasing focus lately from DOJ on punishing companies for having data but not using it adequately in their compliance program. So I think those are questions that really should rise to the board level at this point.
Right. And Ed, I wanted to ask you, as a final area here, a similar question from the standpoint of a compliance officer. I'm a compliant. You see the compliance officers in the cases that you're involved in. And what advice do you have for compliance officers to stay out of trouble with some of these cases, the key TAM cases and the key TAM cases?
I mean, I would just say that, coming from that environment, it's a very difficult job you have being a compliance officer because, your job essentially is to monitor the behavior of other people in the company and practices. So, you got your revenue facing people and your commercial people and your marketing people, but then you have your compliance officer who basically is pushing water uphill in some cases. So I think it's very important that when you are a compliance officer, you have to have very, very strong alignment and support from the board and the CEO, because if you don't, you'll never succeed and nobody will take you seriously. But I think beyond that, there are two types of compliance officers. One is a type who just administers the program as it exists. The other is the type that is going to try and predict areas of focus and scrutiny. And it's those areas, looking at trends, looking, what the government civil division, key TAM task force is saying are going to be priorities. Looking at things, new business practices, for example, interactions with, like we were just talking about, Lauren mentioned a lot of these interactions, but, one area we know is under scrutiny is the government is looking at fees paid to entities like PBMs, administrative fees. They're looking at functional fees paid to distributors and questioning the bona fides of those payments because they're exempt from best price. So anything that goes to that price has got to be scrutinized. And to that extent, you better understand what the fee's for. Is it based on fair market value? Is there a benchmark? Are you really receiving bona fide goods and services of value for those payments? But being a compliance officer, it means not sitting in your office, but getting out in the field, interacting with the folks in the field, riding along, visiting, and really just trying to predict, based on your business model, where where liability is going to be created. Like, for example, if you have a company that has hospital-based products and participates in the 340B program, you should be scrutinizing that to a much higher degree, because that is an area that the government has targeted for enforcement. But it's just basically just being proactive and not reactive, I guess, is it would be my advice.
I do have one final question. For this series, we've been doing a LinkedIn poll with our subscribers. First time we've ever done that, because they have shown such an enormous interest in this series and the podcast we've been doing. So the one question I wanted to ask that one of our subscribers asked, and it has to do with the state involvement. Historically, the state attorneys general have been involved in a lot of these cases. And as they become more aggressive in regulating drug prices through transparency laws and affordability boards and anti-price gouging statutes, I'll start out with Lauren, and then Ed, you're going to have the very final word here. Lauren, where do you see the greatest enforcement risks emerging for manufacturers and other industry stakeholders from states?
I think historically where we have seen the greatest independent state involvement is in Medicaid issues, Medicaid best price type issues, or issues that are specific to Medicaid. I think a lot of times you see the states joining in where there's a federal case, but where you see states acting independently, I would say the Medicaid best price area is really key.
Ed, any perspective on that?
I would say that we're seeing new trends in key TAM, pursuing the so-called causes to be submitted liability. And what that really means is they're starting to look at third parties adjacent to pharma. For example, McKinsey is a perfect example. And in McKinsey, the allegation was that they facilitated the opioid crisis by essentially collaborating with and creating the market for opioids with Purdue and with Endo. And what you've seen is, after the wave of the opioid cases, you're now seeing key TAM cases, but you're also seeing states being very involved in pursuing those theories as well. So even though it's not technically a key TAM, it ultimately arises from action that impacts price. Now, Medicaid, Medicare, other types of government programs that have had to pay for the crisis, but you're seeing a nexus there for states to join in and going after third parties like McKinsey and PE firms we see as well. So I think you're going to see that trend continue.
Right. On that note, Lauren, let me thank you for really educating me a lot. I'm sure a lot of our listeners about what's going on in this area. I've been involved in this, as I mentioned before, for a long time, but I wasn't aware of the nature of what's going on right now and the level of activity. Overall, I want to thank our partner for the series, White Case and BRG. They've been great partners in putting together a great series of podcasts on drug pricing and some of the issues that face companies these days. We couldn't have had two better partners for this series. I also want to thank our podcast creator and executive producer, Michael Levin Epstein, our assistant producer, Sam Hoffmeister, whom I can report is a new father. Congratulations to Sam Hoffmeister on his new family. If you want to find out more about our podcast, visit our website, fdawatch.net. I urge you to subscribe, not just follow, but subscribe. Then you get notices via email that we have a new episode. We're now approaching 25,000 downloads on these podcasts. We've had a very, very good reaction. And again, I encourage you to subscribe, fdawatch.net. As we say at the end of every episode of FDA Watch, if you really want to watch what FDA is doing, listen to FDA Watch. This is Wayne Pines.